witches and wizards of the world!
Shh!
Sorry. This is the Hogwarts Chaplain coming to you from Hogwarts Library, in which we continue to hear from portraits who would like us to keep our voices down, so we will have to whisper our wisdom on the broadcast today. My friends, all the students, as you see, are down in the Great Hall having breakfast, and then we will have morning prayer, but I've taken a few minutes to come up here to speak to you from the Muggle Studies section, particularly books on legal history in the United States of America, that we might better understand the developments around the Supreme Court. My friends, you may wonder why we're talking about this on a broadcast today. After all, 48 hours ago, the United States swore in its most recent Associate Justice on that court. So aren't things over in terms of current events? My friends, if you consider what happened and how it happened in the past 7 days, you will realize that there are lessons we must learn. There is a call to action which we must consider and perhaps accept in the resistance when we look at what has happened over the last 7 days and what it says about justice in America moving forward. But I thought it might be fun for those of you who are Muggles to hear a little bit about the history of the justice system in the magical world. Sorry again. Sorry. Where was I? Yes, right. The Wizengamot. My friends, the Wizengamot is an assembly of wise people in the wizarding world that functions as the judicial system for witches and wizards and muggles who come into contact. You know there are some times where people who are squibs or other non-magical people get caught up in the justice system. It happens, and hopefully justice is administered fairly and without respect to persons in all cases. My friends, the Wizengamot is a very old institution. In fact, it's 200 years older, according to Professor J.K. Rowling, than the Ministry of Magic itself. The Wizengamot was founded in 1544, my friends. Where were you then? And the Ministry of Magic is not founded until the 1700s. So the judicial system was so important in the wizarding world that it existed 200 years before any executive or legislative branch was official. The Wizengamot has 50 members. Think about that. Think about the wisdom. And since 1544, according to Professor Rowling, there has always been both men and women and people of all backgrounds on the Wizengamot. In that way, it has functioned as more or less a legislative body, because when you look at the system in the wizarding world, you'll see that there really is the Minister for Magic and the Ministry, a kind of executive branch, and the Wizengamot. There is not, to the best of our knowledge in the history, any kind of parliament, but the idea was the Wizengamot itself was a broad enough representation with 50 members that they would have a good idea of what or what was not good law. They made lots of laws, my friends. It is a legislative body in function. In fact, we know that Albus Dumbledore himself authored many of the laws that were then enforced by the Wizengamot. Another piece of wisdom from this organization that I think would help Americans is that of the 50 people, according to Professor Rowling, there is in fact a youth representative, a voting member of the Wizengamot, until you are 17, and then you must leave. So the person voting can only be up to 17 years old. Think about that, my friends. That is not handing the justice system over to children, but it is saying that there is a voice there. And if that person can speak up or answer questions, they might guide the eventual consensus. Can you imagine, my friends, if we had a youth representative on the Supreme Court of the United States of America? Now, other lessons to be learned, though, is that there do not appear to be what we would call lawyers in the system. This is definitely a weakness, my friends. It appears that someone comes before the court, and there are certain honorable people, like Albus Dumbledore in the case of Harry Potter and underage magic, who can arrive and help out the person on trial. But in general, it seems to simply be the person accused and the Wizengamot. So, my friends, it becomes very difficult to figure out how someone that doesn't know how to articulate their case would receive equal justice. It seems like the system is built on the fact that among the 50 people, there might be someone who could sort of help the witness or bring to light something the witness was not able to bring to light on their own. They might be able to help the accused in the same way. So the Wizengamot functions as both an interrogator and perhaps a defense attorney, though it's muddled. So that's not something we would want to see in the American system. But there is a wisdom to the idea that there is a large number of people who are actually making the decisions, unlike the United States of America, which currently now only has 9 members of the High Court. It is important to consider the motto of the Wizengamot. It's a Latin phrase, my friends: ignorantia juris neminem excusat. What does this mean? Shh. Sorry. What does this mean, my friends? Ignorantia juris. Ignorance, juris, of the law. Neminem excusat is no excuse. Ignorance of the law is no excuse. This is an interesting motto, my friends, because it demonstrates the philosophy behind both law in the wizarding world and, honestly, British common law, which comes into the United States legal system as well. It is called natural law. And the idea of natural law is that by nature, human beings all share conscience. There are impediments to this conscience: mental illness, different sorts of passions, or things that can interrupt a rational process. But the understanding, the conviction of natural law, the conviction that undergirds British common law and the American legal system is that each person has a conscience. And in most cases, it is that conscience that naturally communicates a general sense, not things like speed limits and whatnot, but in a general sense, the moral laws, which many of them are seen as universal. Sure, there are cultural differences, profound cultural differences, my friends. In fact, libraries are full of the cultural differences we see, even in one's definition of right and wrong. But the idea that really creates and ignites British common law and law in the American system is that there is still some kind of core conscience that is shared by people. Think, my friends, of the trials at Nuremberg, when you had a group of people who said they had been raised in a culture that told them that Jewish people were not, in fact, people, and that was their defense. They were doing what they were told. They were following orders. But remember what happened in that trial, my friends, and it was a perfect example of the principles that undergird British common law and the American system and natural law theory in general, which is the courts were able to say to the Nazis on trial, it doesn't matter what you read or what other people said, because you are a human person. You have a conscience, and you ought to have known better. It is like the motto of the Wizengamot. Ignorance is no excuse. Yes, there are laws of your society, and you may in fact have had to go to jail, break those laws, believing that they were unjust laws, but that your humanity has at its core not a neutrality to right and wrong, but a leaning toward right and a leaning away from wrong. And they were held accountable at Nuremberg. One wonders, my friend, in the modern age, in the 21st century, if such an international trial could even happen. Have we lost our consensus entirely that whether you are in Beijing or Boston or Bangalore, that there is a sort of shared human conscience? My friends, there are people in the last century, during the Nuremberg trials, who continue to say that natural law was not the basis of law. In fact, the rise of the Nazi Party is an example of a different view of laws. In fact, law schools in Germany under Hitler were actually told not to teach natural law philosophy anymore. They were instead instructed to teach what's called legal positivism. It sounds like a benign thing, maybe even something quite good. But legal positivism is really the opposite of natural law. And what it says is how you know what's right and wrong is you simply look at what is legal. The law becomes the positive affirmation of right and wrong. In natural law theory, you know what is right and wrong, whether or not it mirrors the conscience or the natural moral law. So laws are a reflection of right and wrong. In positivist thinking, what you have instead is laws reflect to people what morality should be. So if you make something legal, you are also making it right. If you make something illegal, you are making it wrong. Martin Luther King, the great wizard in American 20th century history, wrote a whole letter against this kind of legal positivism. In his letter from the Birmingham jail, Martin Luther King argued that legal positivism is wrong. We must not look to the laws to know what is right and wrong. We must look to right and wrong and then make laws reflecting that. He said, sometimes we make laws that reflect what is right and wrong in our conscience and in scripture and in wisdom across cultures. And other times he said we make laws that are incorrect, and we know they're incorrect because they violate our conscience. That's what he wrote about in that letter. He talked about Immanuel Kant. He talked about the Enlightenment. He actually talked about Aristotle. My friends, he threw everything in Western tradition at this question. And in every case and in every decade, he found voices that continued the hymn, the strain of truth, of natural law, that we know right and wrong from who we are, not what we read or who is in charge of us. And the letter from the Birmingham jail said, laws of segregation are wrong. It doesn't matter that it's legal to segregate, because it is wrong morally to segregate, and occasionally we have to fix our laws. My friends, how does this affect your life, you and the resistance in America? Well, consider the end of the filibuster. And we must consider this particular event last week in the United States Senate, when the person in charge of that body, a muggle named Mitch McConnell, decided that he would change a long-standing tradition in the Senate in order to get the current muggle president's appointed Supreme Court justice through the process and onto the court. Mr. McConnell decided to change what is called the filibuster. The filibuster! What a ridiculous word! Filibuster! Sorry. And what the filibuster means, very quickly, my friends, for those of you who are unaware, in the House of Representatives, you need 50% plus one to pass any legislation, or rule changes or things like that. But in the Senate, there's always been a tradition that when you debate a question, before you go ahead and vote, in which in most cases the majority vote is also enough to pass the law, that you have to agree as a group to end the discussion. These are called cloture votes. And what they represent, my friends, are a super majority, or at least they did. The idea was, although you only need 51 votes to pass certain pieces of legislation similar to the House of Representatives, that the Senate was different. It was constituted, literally constituted, different than the House of Representatives, in that in order to vote, you have to have 60 people agree to end the conversation about the vote, to end the debate formally. And as a result, there has always been a tradition in the Senate that you had to get more than 50% of the room. You needed 60 people to agree to stop talking and to move forward on a vote. And the result was that you couldn't just have a mere 51 people, you had to get 60 people, which means you needed more consensus and a larger group, and probably you couldn't have just what you wanted in the majority. Now, it is possible that a party could have held more than 60 seats, in which case there wouldn't have been that much difference. But over time, there, generally speaking, has never been a party that had more than 60. So you really needed some of the other side. And the idea was this was a kind of check. And it meant that, yes, you could vote yes or no on pieces of legislation, but you had to get a supermajority of people to agree, a larger Wizengamot, to agree that it was time to stop talking. That is what changed last week. The muggle, Mitch McConnell, has decided, and it is now the rules of the Senate, that there is no more ability. You cannot call for 60 votes to end a discussion anymore. 51 is enough. So what is concerning about this, my friends? Well, what it means is, up until now, presidents, of course, were going to nominate judges for the Supreme Court, or the federal court, by the way, which is hundreds of lifetime appointments in courts all over the country. Well, of course, and the reason to vote for a certain muggle president as opposed to another as a candidate was that you wanted that person to choose judges who thought more or less the way they did. Of course, it's always been in the mind of presidents that they would have to nominate people, yes, that were in their party and shared their views, but that were mainstream enough to make sure 60 people would agree to vote on them in the first place. Well, that restraint, my friend, is gone. And as a result now, it is a purely partisan exercise. You don't really need the votes of any other party besides the party that runs the Senate. This is a huge dent, my friends, into the idea that justices, that the judicial branch is somehow, if not unpolitical or apolitical, it was always less political than the executive branch or the legislative branch. My friends, in 1 week, we have watched that distinction melt away. Why does this matter? Let's consider the oath of office that a Supreme Court justice takes. We actually have a copy of it from the Judiciary Act of 1789, all the way back to the founding of the country in the United States. And here is the oath that is said with a few minor changes to this day. In fact, this was the oath that was said on Monday in America by the new Supreme Court Justice, Mr. Gorsuch. This was the oath he took. I do solemnly swear that I will administer justice without respect to persons, and do equal right to the poor and to the rich, impartially discharge and perform all the duties incumbent upon me as Supreme Court Justice under the Constitution and laws of the United States, so help me God. My friends, I read that oath to you because I want to highlight its first clause, that the promise, the oath, the solemn swearing that was taken was to do equal right to the poor and to the rich. My friends, from the beginning of the founding of the Republic in the United States, there is already language that you might call political. It is ridiculous to say that the court has become political, when in the very oath written for the office of Supreme Court Justice, we hear language from 1789 that said, we may in fact have a society that has rich and poor. There will be the oppressors and there will be the oppressed, and among them you must distribute justice. You must be aware then that there are oppressors and oppressed, that there are insiders and outsiders, that there are the haves and the have-nots, and it is part of your job not to be some neutral referee, as many people on the right in America speak of. No, you are not to be neutral. You are to look at people, both rich and poor, and be impartial. But by having to acknowledge that there are rich and poor, you are acknowledging that there are inequities in the society. And that's why we call it the exercise of justice. Not just the spraying of justice, the painting of justice, or the putting of justice. It is the exercise of justice, my friends. Knowing that we live in a society which from the very beginning acknowledges that there is injustice everywhere. My friends, sadly, now that the court has become more political than it ever was, here is the call to the resistance. It now matters more than ever that we elect representatives of us in the House and in the Senate that represent your values. Because, my friends, there is now a direct connection between who is legislating and what judges will be chosen. And remember, not just Supreme Court judges, my friends, but judges on all levels of the federal judiciary. Lifetime appointments that will last for decades. Muggle presidents shall come and go. Even executive orders will be written and overturned. But lifelong appointments of people who will not administer justice will instead step back and simply referee the injustices that we have. This is not a good future, my friends, and it is not the kingdom of God. Keep in mind that just like the judicial oath, the Sermon on the Mount begins, "Blessed are the poor." Yes, my friends, the Beatitudes begins with the same emphasis on social and economic inequality that are found in the oath. The oath is like what you find in the Beatitudes. Blessed are the poor, my friends, which is an acknowledgement that at the time that talk was given, that great Sermon on the Mount was given, that the poor were not being blessed. They were not in 1789, and they are not being blessed now. So my friends, register people to vote. Don't wait till one of the big elections. Register people now. Set a goal for yourself, my friends, that you will have one person in your life register to vote perhaps every month between now and the next election. Because what we find is when people register to vote, they vote more often, locally and on state decisions. So my friends, register people to vote. Because the sad lesson of the last week in America is this: you will get the justice either that you voted for or that someone else voted for.